Hi, everyone. Welcome to Immigration Talk with myself, immigration lawyer John Kasrabi, and my wonderful colleague Anya Sergeyeva. We're going to talk about a lot of updates in U.S. immigration, particularly this interview waiver program that the Department of State started, which people are really interested in learning about. And we're also going to discuss the K-3 visa as an option is very important for expediting the potential of expediting and getting your spouse here to the United States faster if you're a U.S. citizen. But before we start, I want to remind everybody to make sure to like and subscribe to promote this channel, help us with the algorithm, to further this information to help more people. Would really appreciate it. And if you're interested in scheduling a consultation, just email us at info@jqqlaw.com. That's the best place to do it. So, Anya, thanks so much for coming on again. How are you?
Thank you, John. I'm good. How are you? I'm so happy to be here. Hi, everyone. And let's get it started.
Yeah, I'm happy to bring this discussion up, and you're going into a lot of detail about these immigration interview waivers when it comes to the U.S. embassies for a lot of different categories. With how backed up things are, whether you're in India or whether you're in China or wherever, when you're dealing with these cases, getting interviews really hard. This may ease things up with these immigration interview waivers. So, can you talk about what that means and who it applies to?
Yes, so just last week on December 23rd, right, Department of State decided probably it was like a Christmas present for all the people. I don't know. But it was perfect timing. So there is a new rule now, okay? And according to this new rule, now consular officers, they have the right to waive in-person interviews for certain applicants. It's not for everyone. Again, it's not automatic, okay? It's that now they have this authority, okay? And again, we don't know how they're gonna use it. Most likely, I think that they're gonna use it pretty extensively, taking into account that the how many people are waiting in line just to get their non-immigrant visa interviews. Okay, so who this applies to? It's H4, H3, right? L visas, O visas, P and Q visas.
Mhm.
And for also for H2 visas, F visas, M visas, those are student visas, and J visas. Okay, there are certain conditions that have to be met in order for an applicant to qualify for interview waiver, and I will name one by one. First is that they have to apply in the country of their nationality or residence. This is very important thing. Then they were previously issued any type of visa. So, for example, if you had tourist visa before, right, to the United States, and now you're applying for H-1B, and this rule will apply
Mhm.
in your situation. Then the third one is that you have never been refused a visa, and this is very important that uh, it talks about that you have never had any refusal. Later on, I will talk about the new rule for the 48 months for the tourist visa and other non-immigrants visa. But because for the second rule that I'm going to talk later, there you need to have only that you haven't had a refusal after your last visa approved. Here in this context, you have never had a visa refusal.
Yeah, and these are all
Okay,
non-immigrant visas, so work visas, student visas, and those categories.
right. This is correct, and there is no apparent ineligibility. Well, this is clear. And for first time applicants for H1, H3, H4, L, O, P, and Q, uh, for citizens or of the countries that participate in the visa waiver program, if they had previous ESTA and they traveled on this ESTA. So,
Hmm.
for example, if you had ESTA before, but you didn't, because of pandemic, for example, you didn't have a chance to use your ESTA and travel to the United States, under these conditions, this rule will not apply to you. You have to actually have the ESTA and travel on ESTA.
And ESTA is a visa waiver program for certain countries where they don't have to do embassy interviews. They just go online, fill out a form, and they can find the United States. Much cheaper, easier, faster way to do it.
Yes, this is correct. And the same rules apply for student visas. Okay, and again, it's all discretionary. It's not automatic.
Yeah.
Okay, but hopefully it's gonna work well, and it's going to help a lot of people get their visas faster, get into the United States faster. So these are very, very, very good news. Another thing very important that I want to talk about today is that the Department of State extended indefinitely the rule according to which if you want to renew your visa in the same visa category, okay, your previous visa has to expire not more than 48 months ago. Before, initially, this rule was for 12 months. Then they extended to 24 months. Then they extended to 48 months. And this rule had to expire on the December 31st of 2021. Now the 48 months stays there, but they extended this rule indefinitely.
Wow.
Yes.
It's a big deal. It wastes a lot of time when you already have approved visas. You know it's a clean case. They have to get an interview, and it's really hard to get interviews in most countries right now. We have so many people on H's and L's and stuff that are just stuck. These are work visas. So this is groundbreaking stuff, especially for 48 months, because they take consideration the COVID. You know,
Yes. And now I want to go over the conditions in order for you to qualify for this for this rule to apply in your situation. Of course, the first thing is that you are applying for the same visa. This is for renewal.
yeah.
Okay, this is visa renewal, same category, same visa. Okay, then you have to apply in the same embassy as your previous visa, where your previous visa was issued.
Hmm.
Okay, and this embassy has to be the embassy of your country of nationality or residence. Okay, so why is that? Because when you get your visa, you get fingerprints.
Yeah.
Yeah, and this is one thing about it. Yes, and for some reason, from what I see, sometimes if you if your fingerprints were captured in one country, yes, and you go have a visa appointment in other countries, they'll still need to take your fingerprints again, because I don't know how the system works again, but this probably one of the things why it has to be the country where you live and where you previously applied for the visa. Okay, again, you were fingerprinted before. This especially this rule is important for the kids who were issued their visa before they turned 14 years old,
Hmm.
because again, kids, they don't get fingerprinted before they're 14.
Hmm.
And now, for example, your kid had a visa when he was let's say 12 or 13 years old. Now he turned 14, and again, he will not be able to renew this visa because there are no fingerprints on file for him.
Hmm.
Okay. Yes. Then the next thing is that your previous visa did not have clearance received or department authorization annotation. Okay. If you don't have it, you're good to go. Your previous visa was issued again after your 14th birthday. That's what I just talked about, right? Regarding the fingerprints. And your most recent visa was not stolen, lost, or canceled. And for example, here I want to talk more about it. Probably John's going to help me out a little bit. Um, for example, if you came to the United States on a tourist visa, okay, usually you get 6 months of authorized stay, and then COVID hit and you overstayed. Under these conditions, and you didn't apply for extension. Under these conditions, your visa cancels, gets void automatically by law
That's
if you
correct.
overstayed. And again, if you overstayed, if you didn't file for an extension, yeah, this and you came back, now you're applying for a new visa, you will not be able to renew this visa. Again, it's not going to be a problem if you didn't overstay for more than 6 months.
Yeah.
But again, you have to be truthful. You have to tell all this information
Hmm.
in your visa application. If you overstayed from 6 months to 1 year without applying for extension, it's going to be 3-year bar. And if it's more than 1 year, it's 10-year bar. And again, your last visa was not refused. Only the last refusal counts, as compared to the previous rule that I was talking about for interview visa waivers for H1, H4, LP, Q, and O. Right there, you have, in order for this rule to apply, you're supposed not to have a refusal like never, you have never been refused a visa. For this rule, if you're extending the same visa, right, you just have to have that your last visa was not refused. You can have refusal previously, that's
Mhm.
fine, but as long as after you last visa approval, you were not refused any other visas to the United States. Okay, so this is very important to know. Yes, and the last thing that I want to talk about is that there is this rule two, new rule again, for immigrant visas interview waivers. Okay, just one we talked about previously was everything in regards to the non-immigrant visas. Now I'm going to talk about immigrant visas.
Immigrant visas are getting a green card. So non-immigrant, temporary people coming, they're not fully immigrating, non-immigrant, and this is immigrants. People are coming here to stay.
Right. Yes. So, and it applies only for replacement. If you, for example, if you was issued immigrant visa and something happened, you didn't travel to the United States, right? You can potentially you can qualify for this waiver. There are certain conditions again that have to be met. I will go over them now too. Um, Again, I just wanted to draw your attention that it's replacement. It's not that the new visa, it's replacement.
Yeah.
So you had to
These
have
are
already immigrant visa issued previously.
Yeah, these are people who got the visa but couldn't make it to the United States in time because of COVID shutdown. So the visa expired and they need to get a new one. So they've done their interview. They've done a medical one, so they probably will need to do another one. But at least they don't have to schedule an interview to go in person again, which causes more delays and backlog.
Yes, and the first condition that you gotta have a previous immigrant visa issued, and this visa has to be issued on or after August 4th, 2019. Yeah,
Mhm.
and you didn't travel to the United States on this immigrant visa, so you didn't use it. It's the same visa classification and same approved petition underlining this visa. Okay, and this rule expires on December 13, 2023. The previous rules that I was talking about, right? They were the first one in regards to interview waiver for H1, H4, ALP, and so on and so on. This rule will last till the end of 2022, right? And 48 months extension will last for now indefinitely. So just to be clear, yeah, I know it's complicated. I'm getting lost myself too, but that's what it is. And again, this rule for interview waivers for immigrant visas replacement, again, it's discretionary. It's not automatic waiver. Okay, everyone who finds himself herself in this situation, they have to contact their embassy and to see to ask if they qualify. And depending on what the embassy says, new DS form most likely will be required. New medical exam for sure will be required, right? So new fees too will also be required, and probably updated documents, for example, financials, uh, new financial documents like new taxes, um, new sponsorship form, which is I-8 64.
Wonderful. So it's a lot to digest, and different categories are in there. Very technical, but I've been seeing people. I've been getting emails thinking like everything is waived. You don't even need to do initial petition. You just get it. So I really wanted to sit here and clarify as much as possible what the exact situation is, whether you're doing a non-immigrant or an immigrant visa. Thank you, Anya, for that. It's really good to know, and I'm sure we'll still be getting calls on it because it's complex. And again, it's discretionary, so it's not guaranteed that your case will have that. But
Right.
the thing I wanted to talk about next is one aspect of the immigration system is marriage immigration, particular U.S. citizens who get married to foreign nationals. Now the process starts with Form I-130. It's a petition you make to the U.S. government requesting that your spouse would come in enter the United States and get a green card. But this process sometimes takes a while. Now, on average, we're seeing 6 to 10 months for the initial I-130 petition to be approved. This is when they ask to prove the relationship is real. Once that's approved, if the spouse is overseas, you have to do a consular processing and do embassy kind of stuff. There's one way, and there's many ways to request an expedite, but there's one that's rarely used, and annually only a handful or so are approved because I think it's so rarely used. It's called the K3 visa. And the K3 allows you to make a request and say, listen, we have an I-130 pending, the petition of marriage. We got a receipt for it, but we want to bring our spouse here faster. Can we request that? And you could do it by filing form I-129F, which is typically for fiance visas, after filing the initial I-130 and sending that to USCIS, and USCIS will be adjudicating both these petitions. If the I-130 is approved first, then they go forward with the I-130. The family member the spouse does the consular interview, comes to the United States with a green card. If the K3 is approved, actually the I-129F is approved first, then the spouse will do a K3 visa non-immigrant interview, come into the United States, hopefully faster, and then file for adjustment of status. So that's an overview of it. Traditionally, it's not done too much because these I-129Fs are not approved faster than the I-130. And there's a headache of once you enter the United States, you still have to file for a green card. So those are like negatives. If you had filed for the I-130 alone, once they enter, they should get the green card. You're done essentially with getting the green card. But with the K3, you can potentially come in the United States faster. But once you're here, you don't have, you have to file for adjustment of status. You have to apply for a green card. So those are the negatives. But Anya, could you give me your points about the positives with potential filing for a K3?
Uh, yes, there are some downsides and there are some good things about this petition. Um, I just I just want to say that for example, for 2020, for the year fiscal year of 2020, only two K3
Wow.
visas were approved. Yes,
Yeah.
and for 2019 it was five, and for 2016 it's 102.
Okay.
So why is that? Probably, again, a lot of people, they opt to wait for a couple additional months and get their green card right away, rather than having the K3, then coming into the United States, then filing for adjustment, and so on and so on. But because of pandemic, we see that the situation changed, and K3 can really help the initial I-130 petition to move faster. So one thing, a good thing about K3, unlike K1, is that the holder of K3 visa, once they come to the United States, they authorize to work. It's called incident to status. So what it means, once they cross the United States border, they get issued I-90 form I-94, which is the arrival departure record. Okay, and just based on that, they authorize to work. Okay, this is complicated thing, because a lot of employers, they will not even know about what K3 visa is. Again, as I said, last year there were only two of them right, approved. So
Yeah.
and a lot of employers, they will still refuse to hire K3 visa holders, just because they don't know how it works, they don't know the law, and they just don't want to risk it. Okay, K3 can still apply for employment authorization document, which is EID, form I-765. Okay, but it's they not obligated to do so, unlike K1s. For example, K1s, which is fiance of US citizen, they must apply for their employment authorization document before they can start their employment. Okay, this is very important. So the law is like that, but again, how it works on practice, it's gonna be, most likely it's gonna be complicated. Again, because this visa is very rarely used, and not a lot of people are aware of it. The next good thing about K3 is that generally it's issued for 2-year period, and it's multiple entry visa. Again, unlike K1. K1 is one entry visa, right? And it's usually valid for 6 months, and within the six months, the K1 visa holder has to enter the United States. K3, 2 years, multiple entries. Okay, and once the K3 visa holder is in the United States, all right, they can file for adjustment of status, because again, K3 visa was initially they came up with that because to shorten the time of family separation. And this is the visa specifically for the applicants to wait for the approval of I-130 in the United States rather than in their home country. Again, it won't work if petition was already approved. For example, if you have I-130 already approved, you cannot apply for K3. And for K3, you can apply along with the initial I-130 petition, or separately after you get the I-130 receipt. You can send your I-129F K3 petition to USCIS. And again, good thing about it that it's there is no government fee for that, so it's free. You just pay for I-130. You don't pay for
I-129F.
If you file for K3, right? It's not K1. If you file for I-129F for K1, no, there is still you still have to pay the government fee. Yes, so these are the main things about it. And one more important thing is that for K3, the financial threshold is lower because, again, it's not immigrant visa, unlike the IR1 or CR1, which is the visa for spouses of US citizens. And again, very important thing that K3, you can apply for K3 only if you are married to a US citizen. You cannot apply for K3 if you are married to a lawful permanent resident. Okay, important thing. So yes, for going back to the income requirement for K3, it's 100% of John, what is called?
Policy threshold.
Yes, like the poverty guidelines, yes. And for immigrant visa, for spousal immigrant visa, it has to be 125.
So at the embassy, the visa is 100% of the amount, but once you enter the United States and file for adjustment of status, there'll be an affidavit of support there. That will be at the higher amount. So if you're currently making less, but you will make more, that really is beneficial there. We also, interesting thing is you don't need to apply for advanced parole. So typically once you enter the United States and you apply for adjustment of status, you have to stay in the United States, you can't travel. But if you get the K3, you're still allowed to travel, which is unique. There's only 2 other visa categories, or 3. There's the H-1B, the L, the V visa category, which is almost never used anymore, that you're able to travel without applying for what's called advanced parole first, a special permission, which could take 7, 8, 9 months. So if you need the flexibility of being able to travel back and forth, you have family or business or something overseas, while your adjustment status pending, it's really helpful visa category to get in that sense. It's very positive.
Yes, and important thing about not getting advanced parole, your K3 visa has still to be valid in order for you to go back to the United States.
That's correct, yeah.
Yes, but you don't need advanced parole.
Yeah.
Even after you apply for adjustment of status.
Yeah.
This is one of your exceptions.
Yeah, that's one thing. Now, one thing we've seen is, although it's rarely approved, I have clients who requested, and we have filed I-129F K3 petitions after filing the I-130. And about, half the time, it's interesting, we'll see the I-130 be approved faster. So instead of taking 7, 8, 9, 10 months, after we file for the I-129F to get a K3, all of a sudden the I-130 is approved in 3 or 4 months. So there is some speed up that happens there sometimes. It's not consistent. That's the thing. It's not a rule or something, but it may be something to do to do it. So you kind of have to debate it. Do you want to do the I-130 to enter with the green card and just be done with it? Or do you want to run the risk of potentially having the K3 approved, which will require the foreign spouse to enter the United States and then file for adjustment of status, which adjustment of status, has $1,225 fee right now. They may increase it. There'll be an interview probably. There's another 7 or 8 months of waiting, maybe more. Although you could work incident to status, an employer might not understand it, so there's a headache there. Getting a social security number and a card, you should be able to get it, but social security offices are inconsistent. So you kind of balance out what your life goals are and what you want to do, and you give it a shot. But there's no filing fee for it, at least, so that's a big positive there too.
Right, and for your kids, also they will go together with the K3 visa holder. They will get K4 visas as long as they're not married and they're under 21 years old.
Great. Well, thank you so much for that. We're going to be talking a lot about this topic. And we do a lot of clips, the shorter clips about specific things. So check out the YouTube channel for JQK Law Firm. We're on Facebook, LinkedIn, Twitter, TikTok. We'll be publishing stuff there as well, and all over the place. So definitely check us out. And if you want to schedule a consultation to discuss the K3 visa, just email us at info@jqklaw.com. Thank you, Anya, for the information.
Thank you, John. Thank you everyone for watching, and please like this video and subscribe to our channel, and see you all next week.
Bye-bye.